your eyes. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the appellate will join here. If you attendance, you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. As is our usual custom, I will begin with the call of the calendar. Please know that we have more than 5 hours of argument time requested, so I'm going to ask that you limit your time request to the time you actually need, not the time that you want. Understanding that we are familiar with your case, oftentimes more than you wish we were. So, and please know that the time allotted is for you. That time restriction is for you. So if my colleagues think you are so brilliant and it causes them to ask more questions, I let the clock roll, okay? So please keep that in mind when you make your argument request. All right. People versus Danny Novas. Okay. 5 and 1 and 5. Myra versus Danielle. Submit. Lennon Mullins versus CBS Broadcasting. Okay. People versus Brandon Jimenez. Submitted. Fora Financial Advance versus 4 Pillar Consulting.
8 and 2, please.
Okay.
Respond on request 10.
Okay, 5 and 2 and 6. Lee versus Royer is a submit. Lee versus Grimbald is a submit. Moby Richard Holdings versus Ramo. Submit. Allied World versus Golan Bach Eisman. Okay.
And respond to request 5 minutes.
All right, let's do 7 and 2 and 5. Mafi versus A&O Smith Water Products.
Good afternoon, Your Honor. Appellant requests 10 and 3. Respondent requests 6.
7 and 2 and 6. Shasha versus Malkin.
Appellant requests 7 and 2, Your Honor.
Okay.
Respondent requests 7, Your Honor.
7 and 2 and 7. Walcot versus Wheels, Inc.
Appellant 3 and 1.
Okay.
Good afternoon, Your Honor. 3 minutes.
3 and 1 and 3. Thread Council versus State of New York.
The appellant, Your Honor, 9 and 4. 9 and 4 for sale.
Okay. Let's do 8 and 2 and 8 and 2. And Chapman versus Tovar is a submit. First case on the calendar is People versus Novas. You may proceed.
Good afternoon, and may it please the court. Adriana Finger of Debevoise and Plimpton, in association with the Office of the Appellate Defender on behalf of the appellant Danny Novas. The verdict in this case was against the weight of the evidence because the prosecution failed to sustain its burden of proving beyond a reasonable doubt that Mr. Novas knew or had cause to know that an injury resulted from the February 11, 2018 incident.
Counsel, wasn't there testimony from a passenger in the defendant's car that would lend itself to some rational inference that he would have known? I'm talking specifically about Villar's testimony.
Yes. So while Villar's testimony does lead to a rational inference, can lead to that inference that was drawn, that the jury drew, it also leads to a reasonable inference that Mr. Novas thought that Mr. Gomez had slapped the side view mirror, and all
Well,
the
then
evidence
doesn't
is
it
also
become, doesn't it become an issue of credibility that the jury was, that's within their purview? Why should we change that?
because sometimes the juries get it wrong. And while in this case, it is true that the
For
jury
us to say that the jury got it wrong, there would have to be such a evidentiary showing. Where is that in this record? So overwhelming that the jury could not have possibly reached the verdict that it reached on these facts.
while this court has previously ruled that there was legally sufficient evidence to sustain the verdict, under a weight of the evidence review, there are also other compelling and more reasonable inferences that can be drawn from the evidence that was presented on the record, such that Mr. Novas only
Like
thought
what?
that something.
What was so overwhelming that we should overturn the will of the jury who heard all this evidence?
Well, all of the evidence is also consistent with the view that Mr. Novas.
And they had a right to decide it wasn't. So again, what is the overwhelming evidence? Because that's what we have to find to overturn this jury's verdict.
Well, under a weight of the evidence review, there are more compelling evidence, more compelling inferences that can be drawn from the evidence that was presented, so that there does exist reasonable doubt here in this case.
Like
And
what?
in this case, Justice Clott.
Like what? What
Where's the reasonable
evidence?
doubt?
What evidence points to reasonable doubt? The victim says, who ends up with a quite severe fracture of 2 bones in his legs requiring surgery, right? He says he hits the windshield. So how does a driver not see that?
He did not hit the windshield. The evidence does not, that is not in the record that he hit the windshield, Your Honor. Instead, the evidence is that the conditions of the night with the elevator, there was limited auditory, limited visual context. The nature of the force of the contact was was limited in that Mr. Gomez, excuse me, said that the car struck his leg below the knee, above the ankle, and only was enough force to push him over to the side. And his medical records indicate that he was not thrown, but just fell in place and caught himself as he fell. And Mr. Gomez was running
And that caused the
diagonally.
comminuted fracture of his, isn't that this case?
Yes.
You're looking
yes,
at me like I'm crazy.
Yes. Apologies.
Did he tell Mr. Peralta that his car made contact with a person after the accident?
Yes. Mr. Peralta called Mr. Novas on the trip back to the apartment, and during that conversation, Mr. Novas told Mr. Peralta that somebody had hit his car, not that he had gotten into an accident.
And did he tell the police that he wasn't drinking? Or did he lie about drinking to the police?
Yes. So while there is while the remaining evidence of the consciousness of guilt, that is the most weak and tenuous evidence of all the evidence
But I
presented
think
as
that
to
when
the
you
knowledge
put
of injury evidence.
everything together, the totality of the circumstances, and again, we are looking at, because this is really a he said, she said, right? Or he said, however that is. It's a credibility issue. It really is.
Right. And I will say, Your Honor, that Justice Clout was present during the trial and had the opportunity to view the same evidence as the jury and testimony, and he expressed grave reservations about this verdict and set aside as legally insufficient. He, however, did not have the power to set aside the verdict as against the weight of the evidence, as that power rests solely with this court.
Thank you. You'll have time on rebuttal.
Thanks.
Good afternoon. May it please the court. Rachel Bond for the people. The evidence at trial here overwhelmingly established that the defendant not only hit the victim with his car, he did so with such significant force that it caused a comminuted fracture to the victim's leg. It also caused a crack in the bumper of the car. He then drove away and admitted that he had seen.
And the bumper of the car has some blue tint to it, like
Correct, yes, it
like the
does.
victim's blue jeans.
Well, it wasn't tested, but that was an inference that the people urged the jury to make. And I do think it's a reasonable inference here that maybe there was some transfer, some dye transfer. Additionally,
I've never heard of that.
Well,
Dye transfer from jeans? I've heard of paint transfer, but dye transfer from jeans? Was there an expert who testified about that?
no, the blue mark was not forensically tested, Your Honor. However, even without.
And there was actually testimony from a sister or some evidence that there was an accident with this vehicle prior to Mr. Gomez's incident?
Correct. The people's position is that that testimony was entirely incredible, and in fact, it's not even relied on by the defense on appeal as a credibility argument. And in addition, the evidence again overwhelmingly established that the defendant then admitted that he had seen the victim. Both his own witness and the people's witness, Peralta, testified that he knew that his car had come into contact with a person that evening. And then again, the consciousness of guilt evidence that he then lied about anything that would have implicated him in an accident.
Do you think that the surveillance video footage helps your position at all here?
I do, yes. Even though it does not show the actual contact of the accident, you can see the victim run into the street. You can then see the defendant's car drive through the frame. You can see his headlights in one frame, and then you can see him exit the street in another frame. And you can see the victim's shadow fall to the ground.
So but how would that imply that the defendant actually knew that that's what happened? I mean, he kept driving, so maybe he just kept driving because he didn't want to stop, or maybe he kept driving because he didn't realize an accident had occurred.
Sure. So there are a couple of reasons
I
why.
mean, he claims, just so that you can add this to your response, he claims that he thought, according to the defendant, that the victim here hit his side window, shutting it, which prompted him to then ask his passenger to fling it open. Why is that not also, as your adversary argues, susceptible of innocent explanation that he indeed did not think he hit, that the guy hit his side mirror, and that no one was hurt?
Sure. Well, I think the photos of the damage to the car, as well as the surveillance video, as well as the victim's testimony, they all corroborate each other in terms of how he was hit and how he fell onto the car. He was hit below the knee by the bumper of the car. He then fell sort of up the side of the car on the hood and hit the side view mirror. So he did hit the side view mirror. However, there's no evidence other than the testimony of Villar that he slapped the side view mirror. And again, her testimony, I believe, is subject to a lot of credibility problems. She said that they were playing chicken, sort of stopping and going in the middle of the street. It's very obvious from the surveillance video that that did not occur. So the evidence I think here overwhelmingly establishes that the defendant at least had cause to know that there was some kind of injury when he hit the victim with his car. If there are no further questions, we would ask that you affirm.
Thank you.
Thank you.
Counsel, you have a minute, and I'm going to give you her leftover 10 seconds.
Thank you. Appreciated. So to address the point about the video, I do agree that the fact that the car did not stop is evidence that is consistent evidence with a theory that Mr. Novas did in fact think that Mr. Gomez had slapped his car. And that the damage to the car itself is because there was no expert testimony as to what conditions could have led to that damage and expert testimony or reconstruction evidence as to what types of conditions would lead to the injuries that Mr. Gomez sustained. That does not lead to an inferences of what Mr. Novas knew as the driver of the car. Mr. Gomez was hit on the passenger side vehicle of the car under rainy conditions, under loud train tracks. So there's sufficient evidence that Mr. Novas believed Mr. Gomez had slapped the car, and all of the evidence, Mr. Peralta's testimony, Miss Villar's testimony, is also consistent with that belief. Therefore, this court, sitting as the 13th juror, should reweigh the evidence presented on the critical element of whether Mr. Novas knew that and set aside the verdict as against the weight of the evidence.
Thank you. And I'd like to thank you and your law firm for participating in pro bono service to the court. Thank you so much. All right. Mullins versus CBS Broadcasting.
Good afternoon, Your Honors. I'm Judy Shalmetzi from Wilson Answer for CBS. I would have waived my time, but I wanted to make sure that the court has the video, which I think is particularly useful. I had a feeling. It's the plaintiff's record, of course, but I'm happy to cure if the court will allow me to email it to the clerks this afternoon. I'm happy to submit it. I do have it, of course. And when the court does get it, I think it's particularly helpful for the issue with respect to the railing. Unfortunately, the other messenger walks kind of right into the camera, as the court will see, but I do ask the court right over his hand. You can see the plaintiff letting go of the railing, which is to say that he grabbed the railing, held it as he fell anyway, but then ultimately let go of that left side railing that is there. So I will figure it out with the clerk's office this afternoon how to get that video to the court. With respect to the water.
How does, and I will look at the video, certainly, but how does that cure the absence of a railing on the right-hand side?
Under the Hyman case, Your Honor, especially, well, let me back up. In the Hyman case, there was the same kind of thing where there was one railing and the allegation was that there should have been two. The Hyman plaintiff was not able to grab the railing that was there, and yet held the Second Department that it is speculative to say that if there had been an additional railing aside from the one that was there, that would have prevented his fall. The Court of Appeals affirmed that holding. What we have here is stronger than that because he did actually grab the railing that was there. And it does make sense, as the court will see in the video, he is moving in the direction of the second railing when he slips on that last step. He went around the messenger and now he's moving back that way. And as he slips, he grabs and holds that handrail that is there. So for that reason,
Is
Your
there
Honor.
questioning about that during his EBT? Why he had it and then let it go?
He didn't remember grabbing it. He was asked about the railing. He said that he grabbed for the railing and he couldn't grab the railing.
Okay.
But you can plainly see in the video that he's letting go of the railing after the fall. You can see him let go. So it is very clear he may not have remembered. I
Right.
don't know how much it's possible to remember every detail. He clearly didn't remember. But there it is in the video that he did grab the railing. So I do respectfully submit, Your Honor, that it's speculative to say that an additional railing on the other side.
Why is
of
that
Hyman-
speculative?
Oh, because he had the assist of a rail.
Okay, and perhaps because of the mechanism of how he was falling, he wasn't able to erect himself, stop the momentum of the fall. I don't know. I'll look at the video to see if I could figure that out, but I don't see how that cures the absence. I mean, it's one thing if you say the code doesn't require a railing on the other side. That's an argument that certainly would be a good argument, right, if you can make that. But if there is supposed to be one and there isn't, why is that not an issue?
Again, Your Honor, I can only fall back on the existing case law that says that where there is a railing
Yeah, but
that
that's
is
a Second
available-
Department case, with all due respect to the Second Department. That doesn't bind this court.
It is a Court of Appeals case, Your Honor, because that case did go up and it was affirmed by the Court of Appeals on that issue, including on that issue.
Okay,
So-
I'll take a look at it.
Most respect, of course, this court will do what
I
it needs to do,
absolutely
but
will take
most
a look at it.
respectfully. And 5 seconds on the water, Your Honor, the plaintiff himself testified that he was looking at the stairs before he went down and did not notice the stairs being wet until he stepped on it, which is to say that the stairs were moist, for which.
So why
the
was there a
sign-
why was there a sign warning?
There's no question that it was drizzling, Your Honor, but the question is what kind of a maintenance responsibility exists when all there is so little water? It's no accumulation.
Isn't that an issue of fact?
And wasn't there a reoccurring condition of this water coming in?
If there is a reoccurring condition in that hallway, it did not reoccur that day. That day, the only water that existed is the moistness that people apparently dragged in as they came in from the drizzling water outside. There was no water coming down the walls, there was no water cascading down, and there is testimony to that effect, both from Wilson and from the plaintiff himself. And under a whole bunch of cases we cited, and I'm happy to recite them, Berger, Fernandez, all of those cases, if the plaintiff himself testified that when he last saw, minutes before he fell the stairs, there was no obvious dangerous condition, Your Honor, then that satisfies the movement's prima facie burden to establish that there was no condition to cure. And with respect to the amount of water, the response to the hazard has to be proportionate to the hazard that exists. And here, it is a reasonable precaution under the Toner and the Bach case to put a caution sign when the people may be dragging in water. But when there is no indication to, I don't even know what you would do. You could take a dry towel, I suppose, and keep drying the stairs, but there's nothing else on the stairs that could be cured.
Thank you.
Thank you, Your Honors.
All right. Fora Financial Advance versus Four Pillar Consulting. You may proceed.
Good afternoon, Your Honors. Morgan Lux for the defendant appellant. We're here today because the tortious interference claim is clearly duplicative and legally deficient. The court allowed the tortious interference claim to proceed despite admitting that it might be duplicative. Duplicative tort claims are prohibited under New York law. In the complaint itself, at page 41 of the record, paragraphs 8 and 9, the plaintiff
Does
in
that tort claim assert any additional damages that aren't already being sought in the primary, the first cause of action?
No, the tort claim follows the same conduct and the same amount of damages in each cause of action.
Okay.
And this is incorrect under the Clark-Fitzpatrick rule. Moving on to my next point, the tort claim fails to plead but for causation. The judge ruled that at the very early stage, all you have to do is give notice. But
Does there have to be a more definitive statement for this type of a claim for tortious interference with contract?
it can't be based on scant speculation. There has to be some facts that plead that but for the defendant's interference, the plaintiff and the merchant would not have defaulted under the contract.
So was that pleaded or not?
It was not pleaded. There was no, it wasn't even addressed in the decision. It wasn't addressed on the transcript itself.
No, I realize it wasn't. The judge was concerned about tortious interference. She wasn't sure really if the claim was made out, but she said, well, it's early along, it's a motion to dismiss, we'll leave it in at this time. She dismissed 2 causes of action, but not that one. But looking at the complaint, I mean, is there any place that it's addressed exactly, you know, what the claim is for tortious interference, as opposed to the breach contract, which she left in, of course?
I've searched the entire record. I just don't see a loss causation link that would lead the court to believe under well-established case law that there was a direct injury here. There's no proximate cause or direct cause pled.
But what about the breach contract claim? You think that should be dismissed also, right?
It's not in our papers here, Your Honor, but I do think that the breach of contract claim should have been dismissed. I don't think that they were complete. I think it was a disjoint pleading, and they were all grouped together based on 4 different contracts, and only 2 of which include the term stacking. 2 of which don't even have anti-stacking provisions.
Would there be any reason, would discovery maybe resolve this, or is that not possible?
Your Honor, the court had everything in front of them to decide this case. This was an ordinary contract dispute turned awry, where it ended up giving, and that's my next point, Your Honor, it ended up giving the plaintiff in this action a 100% guarantee with a full refund on commissions earned by my client, which in and of itself, which I'll get to my next point, already appears to be a liquidated damage clause. That is a penalty.
Okay, but this provision with regard to liquidated damages was entered into by 2 sophisticated parties that both were represented, correct?
I understand, but and yes, Your Honor, that is the case. But there is controlling law in Columbia University that included 2 sophisticated business persons, where the ratio between the damages claimed and the actual alleged injury was 64 times what the alleged actual injury here was, or in that case was. And here, in this case, it's 104 times. The damages would equal approximately $500,000 based on, I believe, net profit to my client, or net benefit is about $5,000.
Isn't it too early, though, at this point? Don't you need to have discovery to see the enforceability of that?
Facially defective claims like this are completely disproportionate, and it's clear on its face that 100 times is a penalty. 104 times, that ratio is a clear penalty.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. Cassandra Walsh from Oto Scrivo LLC on behalf of plaintiffs, respondents, Fora Financial.
Can you just pick up that thread that your adversary was speaking about, the liquidated damages and the proportionality of it?
Yes, so the liquidated damages are a fair and reasonable estimate of what Fora Financial could potentially be damaged when its broker, defendant, breached the agreement, including but not limited to by stacking. So Fora Financial is in the business of small business lending and other financing agreements. When a merchant is stacked, and that's wrongfully given a loan or a different financial arrangement by another company that Fora is unaware of, it drastically increases the chances that Fora is not going to collect on the agreement that it just entered into. And they enter into these agreements.
So why should, do you agree with your adversary's assessment that this liquidated damages returns over and above your actual losses, over 100%?
No, Your Honor. And
So that is not accurate.
Not, in their papers, they argue that it is
I'm
the
asking you,
entire
is
contract
that,
amount.
is your client recovering in excess of 100% of its losses?
I would say no. It's designed to recover 100% of the remaining balance on the contracts with the merchants. That doesn't account for the extra collections, agents, the extra underwriting work that Fora Financial does in the background.
And because this number might not be so easily ascertainable, it would vary. That kind of takes away from it's a penalty argument.
Exactly, Your Honor. When they entered into the agreement, the nature of Fora Financial's business and the agreement with Fora Pillar to refer certain merchants to Fora Financial, there'd be no way to know whether they were going to get referred contracts for $20,000, were they going to get referred contracts for $500,000, what was going to be the damage.
So the issue before the court was really whether or not it was facially unenforceable. Otherwise, we would leave it in. You might never get these damages. You might not win the case, but it was just leaving it in, right?
Correct, Your Honor. This is a pre-discovery motion to dismiss. We recognize, and the trial court recognized, that this issue might come up again on summary judgment. We might expect that it will.
Definitely.
Yes. But we are.
You could bet your bottom dollar on it.
We are not there yet, and to quote the trial court, that is a question for another day.
So what about this tortious interference claim? I mean, how do you, I've got your complaint in front of me. Where do you claim that you make a sufficient showing to even, I understand it's a pre-answer motion to dismiss, but where do you say that there's enough in here? And isn't it also duplicative of the breach of contract? Aren't you going to get this, in any way?
Your Honor, on page 55 of the record is part of our complaint, the pleading for damages for breach of contract, specifically state damages of at least $500,000, the exact amount of which to be determined at trial, plus interest, attorney's fees, and costs per the four-pillar contract. That per the four-pillar contract language is not in our pleading for the damages for the tortious interference claim.
Yes, but what facts and what damage is different from that being alleged on the breach of contract on the tortious interference? Because It doesn't matter it doesn't matter. If the facts are the same and the damages are the same, that is duplicative under our case law and should have been dismissed.
Understood, Your Honor. At this pre-discovery.
No, you
motion
ain't
to
gonna,
dismiss.
nice try, no cigar. You've got to give me more. What facts? Give me one fact that is different from the contract allegation for the tortious interference that would justify letting it continue.
It comes down to the intentional inducement of these merchants and the potential egregious conduct that.
How is that not the same on the breach of contract?
Because as the trial court pointed out, the breach of contract, although it says this interference will constitute tortious interference, that doesn't necessarily mean that that is tortious interference. There's.
But you're arguing in circles because you have not delineated one single thing that is different on the tortious interference claim than the contract claim. And the two, if that is the case, cannot ride together. One has to fall, and usually we keep the breach of contract, which kind of encompasses everything, right?
But if there are separate damages available under.
What are the separate damages?
Punitive
No,
damages
that's
possibly.
not, nope. That's a separate category of damages.
If the liquidated damages clause was for some reason struck down on summary judgment, then we might look to the tortious interference for different damages coming from the merchant contracts, potentially.
Okay. Anything else?
No, Your Honors.
Thank you.
Thank you.
All right. You'll have time on rebuttal. Yes?
I just want to address the fact, Your Honors, that my adversary here, and it's the plaintiff's position that the damages are or were not calculable at the time the parties entered into the agreement. The merchant cash advance contracts in and of itself are based on some certains. And it appears here, based on their pleadings, that the $500,000 sum is based upon the sum certain from the breach of contracts of the merchants from the damages owed under the merchant cash advance contracts. I just don't see a situation where it was not foreseeable to have uncalculable damages. If what they're suing for is the amount due under each of the 4 contracts, how is that not a sum certain?
I know you're not asking the court that.
I'm certainly not.
Okay.
The question is rhetorical. The question is rhetorical.
Okay.
The question is certainly rhetorical, Your
Right.
Honor, but this is a liquidated damages clause that permits a windfall. It allows the plaintiff in this action to both recover from the merchant on what it's our position is a sum certain, and then also proceed against the defendant for the exact same amount. I just don't see a situation where this is not a windfall when they also claw back compensation. They're getting an amount in excess to the alleged, let's say, profit they would receive from the merchant cash advance transaction.
All right, well, it seems to me that this will be back, like I said, in the summary judgment mode, and we will see you ladies then.
Thank you,
Thank
Your
you.
Honor.
Have a good day. Okay. Allied World versus Golan Bach Iceman. Officer, please. I know, yeah, normally we know. Sorry about that.
Of course.
You may proceed, sir.
Thank you. Good afternoon, Your Honors. Michael Munoz for the pro se appellant here, Bach, Eisman, Asor, Bell, and Pesco. We came up on a motion for summary judgment that was brought by the insurer in this case, Allied, and a subsequent cross motion by my firm for summary judgment. And in our papers, we identify, generally speaking, 4 errors that we contend were made by the lower court. The first is the lower court's finding that as a matter of law and without any dispute. Yes, Justice Kapnick, I'm sorry.
Just adjusting that, that's all, sorry.
The lower court's finding that the tolling agreement at issue in this case met the definition drafted by the insurer. Such
Why
that,
did it not? I mean, we all looked at the tolling agreement, obviously. Why else would they have entered into the tolling agreement?
Well, Your Honor, that's a good question, and I think I'll get to that in a second. To start with, the definition of a tolling agreement that qualifies as a claim is a tolling agreement that seeks to hold the insured responsible for a wrongful act. This tolling agreement is not only bereft of any detail about what the wrongful act might have been.
Does the contract require any level of specificity?
The reason I say it does.
I asked you a question, I'd like an answer.
Yes, Your Honor. And the reason I say that is because the contract does not simply say a claim is constituted by a tolling agreement. It is a tolling agreement that seeks to hold the insured responsible for a wrongful act.
But the contract does explain what a wrongful act would be, legal services wrongful act.
Correct, Your Honor. But here.
And what relationship did the law firm have with the underlying insured?
The law firm is the insured, Your Honor. And
All right.
the law firm.
You know what I'm asking you,
The
right?
law firm entered.
So you know what I'm asking you. So we're not going to, let's cut to the chase.
Yes, Your Honor.
Right?
Absolutely.
So the law firm is hired to assist in certain transactions.
Correct.
That first transaction, the 106 Spring Street transaction, something doesn't go exactly right and it ends up in litigation, correct?
No, Your Honor, the reason
It ends up in litigation, correct?
And not litigation that is limited to that issue. It ends up, there's litigation.
I didn't say that.
Okay.
All I said was it ended
Yes.
up in litigation,
Part of a
correct?
litigation, yes, correct.
And then the tolling agreement alluded to that litigation,
Correct, Your Honor.
right? So, gee, I wonder what we're talking about.
Well, the reason why I think there are other reasonable interpretations of the reference to that action is as follows. It's undisputed that my firm, the insured, first approached the client and demanded payment. And in response to that, and only in response to that, the client said, well, we may or may not, as is said in the tolling agreement, have some claims against you, law firm. We want to wait until this massive litigation that we just got involved in is over before we address this. There are many claims asserted in that litigation that have nothing to do with the issue that.
But the only connection between them and the law firm was the litigation, was a legal case, legal representation. There was no other relationship, right?
Correct, but the tolling agreement does not say we may have claims against you arising from this litigation.
So again, does what in the contracts require that kind of specificity? That alluding to the 106 Spring Street action, waiting until that is done, because in response, the law firm said, okay, well, we want a tolling agreement too for our legal fees. So clearly, this was about the legal representation.
No, Your Honor, I don't think that's the only reasonable interpretation of the passing reference to this lawsuit,
Well,
which
what other claims could they? What other claims could there be?
There-
I mean, they represented them in a real estate transaction. The claims would have to arise. What other relationship did Workspace have with your client? They were a lawyer representing a client. So the only kind of claims they would have would be legal fees and legal malpractice, which very often, come together, and that's what paragraph A and B talk about. So I don't know what else it could be and how you could think that you wouldn't want to let your new insurer know about this,
Well, let me
which
answer
is
that.
the issue, right?
Well, whether we had an obligation to.
Right.
And this tolling agreement does not constitute a claim, we argue, and also does not constitute notice of a claim. Exactly what I think is on point with your question, Justice Kavanaugh. The tolling agreement does not describe what type of malpractice, what act or omission. I mean, not in any way. I'm not looking for a draft.
What type of malpractice between an attorney and a client?
Correct, Your Honor.
Is there another kind?
Let me submit this, and I see my time is up. But if
No, it's not up until the light is red.
Oh, thank you. Let me say this.
Kind of like the stop sign.
I'll remember that.
This is yellow. It's sort of like the
All right.
yellow light, almost.
Thank you. Let me just say this. A law firm approaches a client and says, you owe us money. And the client says, you know what? We might have a claim against you also. Okay. How does the law firm put its insurer on notice of a claim there? What does that mean? It's a threat, and a seemingly potentially empty threat. There is no indication.
Well, it's not an empty threat because here we are.
Correct, Your Honor, but at the time, is this a claim at the time that the tolling agreement is entered into?
Well, the litigation was not resolved when you entered into the new policy. And all that was required here was to let the insurance company know that there had been a tolling agreement with regard to this particular client and this particular representation that ended up in a litigation.
The issue here, Your Honor, if I may, is not whether it was wise or unwise to not give notice in that moment, looking backwards, okay? The point is that the insurer drafts this language and explains what the rights and obligations are of the people, and the language has to be construed against the insurer, certainly on a summary judgment motion. And here the insurer did not define a claim as a tolling agreement. Under a legal services malpractice policy, any tolling agreement with any client would constitute a claim, and that's not what this policy says.
Thank you. You'll have time on rebuttal.
Thank you very much.
Good afternoon, Your Honor. Gerald T. Ford. With me is Emily Hart. She's been admitted pro hoc vice, and with your permission, she'll present the argument for the respondent.
Where's she from?
She's from Washington, D.C., the firm of Wiley Ryan.
Very good. Welcome to our fair city.
Thank you very much, Your Honor. So, I mean, this case, I think, really involves just two very straightforward issues of insurance contract interpretation. Whether the claim was first made during the policy period, which Mr. Muniz alluded to, and then whether Gallenbach also satisfied the prior knowledge condition in the policy.
If we're talking about the 106 Street transaction as being the root of all of this, then that would suffice to show that it predates the policy, right?
Yes, the tolling agreement predates the policy, and it also predates when Allied World came on the risk for the first time, and that's relevant to the prior knowledge condition with the August 1st, 2019 prior knowledge date. All right. So I think the critical issue here for both coverage conditions, as Mr. Muniz alluded to, is the tolling agreement. And, I think it's right in the tolling agreement, recital A specifically states that Workspace believes that it may hold claims against Gallenbach and wishes to preserve those claims, and then references the 106 Spring Street action. And I think Gallenbach reads requirements into the definition of claim that just aren't there. Gallenbach and Mr. Muniz is correct that not just any request to toll or waive a statute of limitations would constitute a claim under the policy, because this is a legal malpractice policy, right? So it doesn't just cover anything under the sun. It covers professional malpractice issues. And, in that regard, I think we cite this in our briefing, that if, for example, Gallenbach entered into a tolling agreement with its landlord, and there was otherwise no legal relationship, well, no, that would not be a claim for a wrongful act under this policy. But it was written to be broad, to provide broad coverage for insureds, but there is a condition that it must be a claim first made during the policy period, which is part and parcel to claims made policy. And I think that reading additional details into the definition of claim, there needs to be specific allegations or et cetera, it really ignores the nature of a tolling agreement. And that is simply to preserve the statute of limitations to allow a lawsuit to proceed at a later date, which is exactly what the workspace tolling agreement states in recital A. And so the motivations in that regard aren't relevant. Whether it started out as a fee dispute or something else don't matter, because at the end of the day, it's still a request to toll or waive a statute of limitations involving this 106 Spring Street action.
What else possibly could the claim be here? I mean, given that the law firm represented Workspace as a lawyer, advising them in a real estate transaction, what other relationship did they have?
Well, that's exactly Alley World's position. I mean, what else could it be? We just don't. There couldn't be anything else, and so clearly it is a claim for a wrongful act under the policy, and therefore it's not a claim first made, because as Justice Cohen held in his opinion, the nexus between that tolling agreement and then 3 years later, the lawsuit that Workspace eventually ended up bringing, is very clear, because the Workspace action involves, it alleges legal malpractice against Bach regarding its representation in the transactions that issue in the 106 Spring Street action. So then the second condition precedent to coverage that Bach failed to satisfy is the prior knowledge condition. And here there's two clauses. Alley World does not raise the first clause, but it does raise the second clause. And here, Justice Cohen correctly determined that prior to August 1st, 2019, Bach did have a basis had a basis to foresee that any fact or circumstance, i.e. the tolling agreement, might reasonably be expected to be the basis of a claim against it. And here the key word is might reasonably. It's undisputed, there's no disputed facts in this matter, that Bach entered into the tolling agreement, it signed it, it knew about the tolling agreement, so the subjective prong is satisfied. And then objectively, clearly, a reasonable attorney, having signed a tolling agreement, knowing what a tolling agreement does with its client, might reasonably expect that a claim could result in it, which of course in this case, a lawsuit was later filed. And I think, again, the key word here is might reasonably. So even if, even if there was originally a fee dispute or some other motivations for the tolling agreement, all that's required in the prior knowledge condition is.
Was there a connection between the filing of the action against them and the outcome of the 10 Spring Street action?
I don't know that. I think that the 106 Spring Street action was ongoing. I'm not sure that they had resolved that prior to the Workspace action being filed.
Okay, thank you.
Thank you.
All right. You have 2 minutes.
Thank you. I guess the main point I would make, Your Honors, is that we're here on a summary judgment motion on a contract drafted by Allied. And I understand that if you look at this retrospectively and you judge from sitting here today, you can draw a connection between the eventual claim against my firm and the tolling agreement. But at the time, until that lawsuit was filed, there is no evidence in the record, including in the tolling agreement, that the firm had any idea whether Workspace would sue it and over what. I mean, yes, you could say over services that we provided.
Also, recital C of the agreement states, the parties desire to avoid litigation at this time.
Correct.
Doesn't that allude to possible litigation in the future?
The essence of a tolling agreement is expressing the possibility of litigation.
Okay, and then Section 6 says that you were all represented by attorneys, sophisticated parties, you knew this binding agreement, correct?
The tolling agreement, correct, Your Honor. What I'm focused on is the contractual definition and whether it's appropriate on summary judgment where there are other reasonable interpretations to.
What is the other reasonable, I'm sorry, what is the other reasonable interpretation of,
Is that
of recital A?
The allusion to this 106 Spring Street lawsuit that is in the tolling agreement is not explicitly or implicitly a connection to the supposed
It
claim.
would need to say something like, your representation of us in the 106? Is that even really
We
necessary?
didn't, and we didn't represent anyone.
And what is missing?
So what's missing is any concept. We represented this client on two complicated real estate transactions, sale of 2 commercial condominiums for purchase prices in one instance, I believe, of $20 million, and a failed purchase on the same amount.
We know that, and you
Where
entered this agreement, and they say, if we have any claims against you regarding this action, we want to toll it. And then you respond, and by the way, if we want any unpaid fees, we also will go for it then.
Again, if I may, the tolling agreement was a response to our demand for fees, not the other way around. So that I just want to correct
But it
that.
doesn't matter. You signed the tolling agreement and it says what it says.
But what would they be suing you for? What would Workspace be suing you for? As my colleagues are saying, they didn't say legal malpractice. So what, in your thought, would the claim be?
What I'm trying to express is not just what would the title be at the top of the cause of action, but what are we being sued for? There was hundreds of hours of work performed.
So you're saying they had to basically attach a complaint, a proposed complaint?
As I said earlier, I'm not advocating that, Your Honor.
It seems like you are.
Okay, what I would say is that some indication as to what the malpractice is. Did we misinform them about construction law? Did we misinform them about how?
Where does it say that they have to give you that kind of detail for you to know that there might reasonably be a legal malpractices claim or legal services claim in the future? I mean, this is summary judgment. You have an obligation to lay bare your proof. I don't understand what else is out there that isn't before us now.
Then and I see I'm out of time, so let me just answer your question this way. Policy says that the tolling agreement must seek to hold the insured responsible for a wrongful act. What is the act here? What is the act here? It's just.
I got your argument.
Thank you, Your Honor,
Thank
very
you.
much.
Before we proceed with the next case, I want to welcome bienvenidos a los estudiantes de Madrid. And your master's program, we are happy to have you here. Welcome, and we hope that you enjoy what you see. And for those of you who may pursue law, that nothing that you see scares you away from it, okay? You're welcome. All right. Mafi versus A.O. Smith Water Products. No, not at all. Okay, you may proceed, sir.
Good afternoon, Your Honors. May it please the Court, Michael Garvey on behalf of Appellant Burnham, LLC. Burnham is here to ask this Court to apply settled Court of Appeals law and overturn the unprecedented $38 million runaway lung cancer asbestos verdict in this case. And I want to start by emphasizing that this is a lung cancer case, not a mesothelioma case, which I know this Court has a ton of experience reviewing.
And with lung cancer, and none of them are pleasant. You can continue. I'd be real careful.
Yeah.
Okay?
But I do need to emphasize, Your Honor, that the two diseases are different.
Of course.
Mesothelioma is, of course, a signal disease for asbestos exposure. Lung cancer isn't. Lung cancer...
But can be caused by asbestos.
At certain very high levels of exposure.
Right.
And that is another difference. Cigarettes, however, are the #1 leading cause of lung cancer. That's not the case for mesothelioma. So there's important differences regarding causation when you set out to analyze a mesothelioma case versus a lung cancer case.
Also, the particular experts that testified in this case have been deemed, credible, and their practices being relied upon for general causation and specific causation. I'm talking particularly about Parker and McWilliams. And how do you view that in light of your argument?
Well, so actually, this Court's decision in Dyer v. Amchem, which is a lung cancer case decided 2 years ago, analyzed Dr. Ginsburg's testimony, who was the causation expert in this case, specifically in the context of lung cancer, and found that the plaintiff there, on summary judgment, no less, was unable to show that the low-dose exposures at issue were sufficient to cause lung cancer in humans.
Well,
And-
here we
and-
have a jury verdict, right? And all of this evidence was laid to bear before the jury, and they considered it. They were told about how much this plaintiff smoked and for how long he smoked, and they considered it. So why should we, as the 13th juror, now disregard the findings of the jury and substitute what you would like us to do for their finding?
And I appreciate that question. I heard you, Your Honor, ask that question in an earlier appeal, so I was thinking about that. The reason, Your Honor, is because there is a long line of authority, starting with Parker and continuing to Nemeth, that says the trial court, and then ultimately this court, is responsible to play a gatekeeping role. It's responsible to make sure that before an expert with great credentials goes to a jury and offers an opinion, that there's the necessary foundation backing that expert's opinion. And so in Nemeth, you saw the Court of Appeals scrutinize how the expert supported his causation opinion to the jury and find that it wasn't reliable and it shouldn't have ever gone to the jury.
But, look, I was on Nemeth here, so I don't agree with that, but they're the Court of Appeals, so they're right, I guess. But it really does come down to the circumstances in each of the cases and the facts of each case. That's why it's specific causation, it's specific as to the facts of each case. I mean, in this particular case, there was no question that the plaintiff had worked where he worked for the number of years he did, and that there was exposure during that time. It was out there about the smoking. Nobody was hiding that, and that was part and parcel of it too. But what makes? Are you saying that there wasn't even specific causation to say that anything was caused by the?
So Justice Kaepernick, I'm saying two things. I'm saying under Parker, the plaintiffs had to put forth scientific evidence generally.
Which they did.
Generally accepted methodology, which we have found before with these, particularly with these particular experts.
Well, so here, the first expert they put on had to estimate the quantity of exposure this plaintiff had to my client's products. And as it turned out, this expert never even analyzed Burnham jacketed boilers, never analyzed jacketed boilers at all. And in fact, he erroneously assumed that every boiler Burnham manufactured contained asbestos insulation. In fact, Burnham stopped manufacturing boilers that contained asbestos insulation 30 years before this plaintiff even started working. And when he was confronted with that at cross-examination, it surprised him because he hadn't done any analysis of Burnham jacketed boilers. So his entire opinion was rested on a false premise. That's not reliable.
Apparently, the jury rejected that.
Your Honor.
The jury rejected that.
As the jury did in Nemeth.
I mean, to the point where it was unanimous on all questions except for the apportionment question. I mean.
Still, Your Honor, I come back to Nemeth and the role that the trial judge and this court ultimately, and I guess ultimately the Court of Appeals needs to play to ensure that there's reliable science backing these experts.
Let me ask you a question, because I see that your time is running out. Just on the issue of the punitive damages, right? Is it fair to say that the witness for Burnham testified that they were aware of certain changes in laws or certain compensable injuries from asbestos, and yet for years they didn't change the asbestos use in their product? And would that constitute the punitive damage? I mean, they're aware of it. Why isn't that willful?
Your Honor, in our view, this one isn't even a close call. To show punitive damages, there has to be an extraordinary record, clear, convincing evidence of conduct that approaches criminality. Multiple trial courts have looked at the Burnham fact pattern and found there's no evidence of punitive damages. The evidence against Burnham is like the evidence against so many asbestos manufacturers. They failed to warn, and the juries find that they, at the same time, should have known about the dangers of asbestos. There's nothing in this record to suggest that Burnham maliciously knew that this particular plaintiff 30 years, 50 years forward might be demolishing.
Is that what is that what has to be shown? That they knew that this particular plaintiff would develop lung cancer?
No.
That's not the standard of proof,
That's not what I said.
counsel. That's exactly what you just said.
No, Your Honor, that's not. What they need to show for punitive damages.
I'm going to listen to this tape,
Okay.
okay? And you'll have time on rebuttal. I know what you said.
All right.
Good afternoon, Your Honors. Pierre Ratsky from Whites and Luxembourg for respondents Romeo and Rosa Mafi.
So just so that we can just have some kind of continuity, just pick up on the issue of punitive damages before you get to the other part with the experts. What in the record establishes the punitive damages?
Certainly. First of all, the standard is not what opposing counsel said, which is that this has to be exemplary misconduct compared to other asbestos defendants. Defendants are not graded on a curve compared to other members of their industry. They're graded on a curve based on whether this is exemplary misconduct compared to ordinary negligence cases, and it certainly is for the reasons Your Honor noted. But even if it were the standard, this case does stand out from other asbestos cases in two main respects. First, there was not a mere general awareness here, as there was in the Maltese case, that asbestos in some contexts could be dangerous. Instead, there was evidence in the record that as early as the 1930s and 1940s, because Burnham was complying with local laws in Pennsylvania and Ohio, that it had actual knowledge of the hazards of asbestos. And its corporate representative admitted as much and said at the absolute latest date that Burnham had actual knowledge of the dangers of asbestos in 1972 with the enactment of OSHA. All of Mr. Maffei's exposures here post-date OSHA. They started in 76. So throughout the entire exposure period, Burnham had actual knowledge, not a mere general awareness, that asbestos was harmful, that it could cause disease, including lung cancer, and that it could kill people. They chose not to warn throughout that entire period, and instead were still purchasing asbestos by the tonnage into the 1980s to use in their boilers. Secondly, this case involves insulation exposure. This is textbook exposure. If you look at the studies in the 50s and 60s by Dr. Selikoff and others, they were primarily concerned with the unique hazard to insulation workers, including those demolishing boilers, such as Mr. Maffei, which he did later on. Also, OSHA, the research underlying OSHA, was particularly concerned with insulation exposures, and its regulations have particular solicitude for insulation workers. So once again, this is not a mere general awareness that asbestos in some contexts could be harmful, which was the case in the Maltese case, which is the one that Burnham primarily relies on.
And in this particular case, there was a prior decision by our court, wasn't there, that said that at least the issue of recklessness should be able to go to a jury. So there's already been a finding that there was at least there was enough out there to go to a jury, and it went there, and they sort of, gave testimony based upon what had already been established relating to this very case and this very plaintiff.
Precisely, Your Honor. And
I think Judge O'Neill-Levy had a question.
Thank you. I was wondering if there's any appellate level cases for a lung cancer asbestos victim that upheld a verdict such as this.
Not in the recent record, but this court has consistently approved of verdicts in asbestos cases, in mesothelioma cases, in the $250,000 to $300,000 per month range. This case involves damages in the $80,000 to $90,000 per month range. So even if there is some sort of inherent discount for defendants in a lung cancer case, that's already built into this verdict. And his suffering here was immense. It was as much or greater than Mr. McWilliams's. I mean, he was diagnosed with stage 4 lung cancer. There is no stage 5. Stage 5 is death. And he was told that it had already metastasized to his brain. He had not one but 2 gamma knife procedures where they drilled a metal helmet into his skull and shot beams of painful radiation directly into his brain.
And that's without sedation.
Correct. He had to sit there perfectly still for the entire procedure to work. He also had a piece of his lung sliced off during robotically assisted surgery. He had chemotherapy, which left him with permanent cognitive issues. His family members testified that he's constantly repeating himself, forgetting names, forgetting words.
And with all that, he still testified credibly to the jury that he smoked. He smoked several packs, and he even smoked after he was diagnosed, correct?
Yes, absolutely. He did not hide that at all. And nor did our experts. They conceded that smoking was a cause, and the jury assigned him a significant share of fault for his negligence in smoking. The comparative fault standard, though, is whether it's to compare the relative culpability of the parties, not the relative causation. And here, Mr. Maffei's culpability was mitigated by the fact that he started smoking before he knew it was dangerous, he became addicted, and that addiction was hard for him to kick. Compared to Burnham, they knew decades before Mr. Maffei ever encountered a Burnham boiler that asbestos on the boiler was dangerous and could kill people. And they simply did not care. And that evidence was a sufficient basis for the jury to come up with this apportionment of fault. It's also a sufficient basis for the jury to find that their conduct was wanton and showed an indifference to human life, and their determinations should not be disturbed. Also, Justice Rosado's determinations in her post-trial decision are entitled to great deference, because she had the benefit of sitting there day in, day out at trial, hearing the same evidence and judging the credibility of the witnesses, including Mr. Maffei.
Counsel's comment during his argument that there were some Burnham boilers that did not have asbestos jackets, and that your client or your expert was surprised about that. Can you address that a little further?
Certainly. So Burnham's corporate representative admitted they sold jacketed boilers with asbestos insulation on them up to at least 1962. He also admitted that Burnham bragged that his boilers could last 50 or more years. 1962 plus 50 is 2012. So that's even post-dates Mr. Maffei's exposure. Mr. Maffei testified, quote, "I know there was asbestos on every boiler that I took out." That's on page 201 of the record.
Was there any evidence that after learning of the dangers of asbestos that the company went about a notification process to all of the buyers of their systems?
Not at all, Your Honor.
Was there any indication that there was any attempt to remediate the boilers that were already out in the sphere of American life with these boilers with jackets filled with asbestos? Was there any attempt to remediate, call them back, service the boilers so that they would remedy that problem, anything like that?
Absolutely not. And that's why Mr. Maffei was destroying these boilers, because they were old boilers, which perfectly fits with the evidence that these boilers would last 50 or more years, which was bragging rights for the company. And so, of course, he was demolishing old boilers. Those boilers still had asbestos on them. They had never contained a warning, and there was no fulfillment of their continuing duty to warn even after the sale of their products.
Thank you.
Thank you.
You have 2 minutes.
Okay. So just going back to punitive damages. New York law is clear that simply knowing about the dangers of asbestos, including knowing about the dangers of asbestos and asbestos insulation, is not enough to support a punitive damages claim. A punitive damages claim requires clear, convincing evidence of something that approaches criminal indifference, malice. And that malice can't just, that malice, and this is where I think we were when I broke, has to be at least directed towards the category of people that are plaintiffs. Understand that the boilers we're talking about here were manufactured prior to 1949. Counsel just quoted testimony about Burnham's corporate representative. That's not what our representative testified to. There were no Burnham boilers being manufactured after 1949 that contained jackets that contained asbestos-containing insulation. And so what you have is the argument that—
But they're already out there. So when one breaks down and a worker has to fix it, they are then exposed to this material, sir.
I understand that, Your Honor, and that's the theory.
So the fact that they, even if the jury accepted as true that they stopped manufacturing them in 1949, that doesn't mean that, poof, they stopped existing in the marketplace, right?
Understood, Your Honor. And this is the recurring fact pattern that exists in so many of these asbestos cases. But it's not the case that punitive damages gets awarded and teed up for the jury in every one of these cases. And if punitive damages can exist on the facts of this case, they could exist on the facts of almost every asbestos case. And I think that that's not what New York law provides for. Could we talk about remitter very, very quickly? Here, the jury awarded $26.5 million in pain and suffering, including almost $20 million for the plaintiff's future pain and suffering after his cancer was already in remission. So you've got a jury awarding $20 million.
But he testified during the trial, I believe, that he still suffers from pain, and he had procedures to his brain and his head that still cause him discomfort.
But the jury's verdict suggests that the pain and suffering this gentleman experienced during his treatment continues unabated for the rest of his natural life. And that's just not the case. He may experience intermittent pain now and then, but he's not enduring the type of treatment he endured while he was being treated for cancer.
I mean, pain and suffering is also loss of enjoyment of life, right? I mean, that's part of it. And that's part of what the testimony was about, that his life, he can't do anything, he's not the same kind of person, he can't be the same kind of husband to his wife, he can't travel with her, he can't do anything that he used to do. So that's also incorporated, it's not just pain.
Agreed, Your Honor. But when when this court is doing its statutory benchmarking analysis, which you have to do in evaluating this verdict compared to precedent cases, I'm confident you're not going to find any precedent cases, certainly not lung cancer cases or any cancer case, where with cancer in remission for the rest of someone's natural life,
but
pays a $20 million.
Except that there's no such thing as being able to say with any degree of certainty that someone is going to be in cancer remission for the rest of their life. And we know that with lung cancer, typically within 5 years it comes back. So who knows? And may God bless this plaintiff and that he have a long life. I'm sure you wish that too.
I agree.
Thank you, gentlemen, for the spirited argument. Shasha Malkin. You may proceed.
Please the court, thank you, Your Honor. Tom Dewey for the Malkin parties. This appeal involves an arbitration award where the arbitrators refused to apply Hornbook law, holding that there was no consideration for a transaction, even though it was common ground that my clients had given up substantial fees to which they were legally entitled.
I don't know about how substantial they were.
Well, tens of thousands of dollars, Your Honor.
In the scheme of the whole thing, that's not substantial.
Well, Your
In
Honor.
the scheme of the underlying contract, a couple of thousand here, that is not substantial.
Well, Your Honor, the Melcher case from the Court of Appeals is clear that the slightest consideration is sufficient to support the monos.
What do we do with the filing with the IRS, I believe, where they claim that there was no consideration?
Let me address that, Your Honor.
Yes, please do.
We said in that filing that we did not pay any consideration, meaning that when we asked for the consent for the overrides, we didn't pay money to the investors. What we told them we would do, and what actually happened, as is clear both on the face of the arbitration award and in the brief they filed in this court, was we gave them a fee reduction. You agree to the override, you get lower fees over time. And you need look no farther than the arbitration award itself, where the arbitrators said, and it's record 32, that we had assigned a pro rata portion of potential incentive compensation due to reductions in the master lease, an assignment worth approximately $50,000 per year if all participants had executed authorizations. You should also look, if you haven't already, at my adversary's brief in this court, where they say, quote, fee payments began in 2009 and were in effect for 5 years. That's actually not accurate. It's a much longer period of time, and you can look at record 534 to verify that. But here you have a circumstance where the arbitrators themselves recognize that the investors got the benefit of the fee reductions. My adversary's brief recognizes the same thing, and yet the arbitrators ruled as a matter of law that there was no consideration. This one isn't rocket science. This is first-year contract law. You cannot have an arbitration award that recognizes that we gave up fees and recognizes on another ground that we had engaged in a detriment, right? But at the same time, that there's no consideration. It makes absolutely no sense. Other grounds that folks have offered up to try and justify it make even less sense. The federal court said, well, gee, the arbitrators maybe were just paraphrasing your argument. Not so. The arbitrators were careful when they said, according to respondents or claimants, they said that expressly. Here, they made an express finding that we'd given up the fees. There's also been an argument that this is a manifest disregard of the evidence argument. The farthest thing from it. The arbitrators recognized the evidence. They agreed with everyone that we had incurred a detriment and that we'd given up these fees, but they then proceeded to reach a legal conclusion that is irreconcilable with that factual.
So the fees you're talking about is the $52,000 a year?
That's correct.
Versus the $304 million in distributions?
Well,
is that what we're talking about?
We are talking about that.
Ah, okay. And so those two numbers in your mind, $52,000 a year is a substantial number up against $304 million in distributions?
I certainly think.
And you think the arbitrator's assessment of that is so off?
A couple of responses, Your Honor. One, when we asked for the override, it was 20 years before the transaction. There was no assurance there was ever going to be a transaction. There was only an assurance the fees were going to be reduced. Two, the arbitrators didn't make that factual finding. They didn't say that the imbalance that Your Honor has referenced that ultimately happened nullifies consideration. Three, I think the reason, respectfully, they did not make that finding is that it would not be consistent with Court of Appeals precedent that said, as I mentioned in the Melcher case, that the slightest consideration can support the most onerous obligation. So while the numerical imbalance that Your Honor referenced is there, we think under Court of Appeals law, it would still be sufficient consideration, as there was additional consideration by increasing our supervisory service.
Except that those, that consideration was given to everybody, whether they consented or not. So that's not really consideration when everybody gets the same thing.
I respectfully disagree, Your Honor.
Well, that's exactly what the arbitrator found.
The arbitrator did find that. The
Yes.
arbitrator found.
Makes sense to me.
The arbitrator expressly found on that point, Your Honor, which is one of the two forms of consideration, that we had incurred a quote-unquote detriment. I don't see how you find that we incur a detriment and that that isn't sufficient consideration under contract law. I want to briefly touch on, if I may, the service issue. First of all, it's not an issue for the Edelman Trust because their lawyer expressly accepted service, so there's no dispute that service of the petition was timely as to them, and that's record five.
No.
Record 503.
No. They did not consent to receiving a service on the action in this way. And it is required that you receive that consent.
I believe.
And the fact that they did in prior proceedings doesn't give you a walk on service on this action.
Two things, Your Honor. The Edelman Trust, if the court will look at record 503, expressly accepted
It was
service
the
of
other
petition.
defendants, the other
Correct,
parties that
Justice
did
Kavanaugh.
not.
That's correct, Your Honor.
And so how do you get by that? I mean, the law and the federal law seems to be very clear. They don't give you too much leeway there. You have to expressly agree that you're going to accept service that way, and just the fact that you've been doing it all along doesn't seem to be enough from what I could see.
So this is an unusual fact pattern where not only were we serving folks by email in an arbitration, there was a parallel federal action that was pending at the same time, right? When we sent them the petition by email, they didn't respond, and then 2 weeks later turned up saying, sorry, no, service is too late. So in answer to your question, the federal authorities are more split on this. Frankly, there are plenty of federal cases, Day and Corinthian colleges, that have upheld email service, recognizing in 2025.
Is that email service without consent to receive email service?
Yes, Your Honor.
Or to
Yes, Your Honor. I would also say that we're now in state court. The state court rule is different. This court
Yes, but you had to have filed it on time in the federal action for us to even entertain it here. But you'll have time on rebuttal, sir.
Thank you, Your Honor.
Good afternoon, members of the panel. My name's Peter Levine. I'm a member of the...
You're going to have to raise your voice.
My name is Peter Levine. I'm a member of the New York Bar. The lead counsel for the respondents is John Griggs, a member of the Bar of Virginia and the Bar of the District of Columbia. And he has been admitted pro hoc vice to present an argument before this court. I'd like to introduce him and ask Your Honor's permission to have him argue on behalf of the respondents.
Yes, of course, and welcome to our fair city.
Thank you, Your Honor. May it please the court. Let me first go to what opposing counsel was talking about, the consideration for the so-called overrides. I would first of all point out that this is a 100-page opinion that the arbitrators wrote. It's based on 8,400 pages of transcript and 540 exhibits. It's a very thorough examination, and they're more than they really address this question of the overrides quite succinctly and quite thoroughly. The one thing
Did
that
they manifestly disregard the law?
they did not disregard the law. In fact, they did not rule as a matter of law, as Mr. Dewey has said. They spent 10 pages talking about the facts of the overrides. They went over those facts, and
What about the fact that your adversary brings up that they suffered a detriment? Why isn't that the consideration?
Based on well, they didn't base it just on the law. What they did is they made a factual finding, numerous facts relating to the consideration that was paid. And this is not merely just a matter of law that they did. They found that it was an issue of mixed law, in fact, and in that regard, it's not really reviewable on appeal. It's a matter that the arbitrators determine, and the legal standard is here, you don't need to go into that in detail. Is there a colorable basis to sustain them? Yes, there certainly is a colorable basis. But importantly, to the extent that there was any kind of consideration worked out, it was for something called a voluntary compensation program, not overrides. The word override is not used anywhere in the documents that they point to as creating this contract. It relates to something called voluntary compensation, and the things that are described in that are a sale of the building or refinancing. The word override isn't used. So testimony of the participants who showed up at the hearing to talk about this, not a single one of them knew what an override was, and all of them explicitly stated that they'd never intended to lose 10% of their shares in an exchange for something called overrides. So there was no meeting of the minds for these contracts. This was an issue that was briefed to the arbitrators, and the arbitrators found in general that they could not enforce the overrides. They didn't just come out and say, oh, it's a matter of law. There was no consideration. That's not what they said.
Counsel, can you address your friend's argument on service?
On the service.
Did you expressly consent?
You mean with respect to the
email
Section
service
205 issue?
Yes.
Oh, well, absolutely. What they're trying to do now is rewrite the whole history of this matter, and they're trying to say that they had a timely filing in federal court.
Was it
Judges
timely?
have said no. It was not timely.
And
Under
the federal
Section
court
12.
already found that the fact that the Second Circuit reversed was not particularly on that issue, it was on a different issue.
The Second Circuit actually didn't get to it because of the Badgerow opinion.
They just
of
found
that
there was
appeal.
no jurisdiction at all, right?
Yes, the question of the service under Section 205, you cannot use 205 if the initial action was not timely filed. Under Section 12 of the FAA, Federal Arbitration Act, you have to both serve and file within the 3-month period. There is a decision of the New York Court of Appeals that also addresses the Section 205 issue, and I just want to put that in the record, if I were, in Markoff versus Community Hospital, 61 NY 2nd 283, at page 288, the court said, the requisite predicate for the application of CPLR 205A is that the terminated action must have been timely commenced. And they say, see Carrick versus Central General Hospital, 51 NY 2nd 242. An action is commenced within the meaning of any statute governing limitation, including CPLR 205A, when there has been service of summons. So that reinforces what the federal court found in saying that, no, you didn't serve it on time. And then they say, well, there should be equitable consideration of that. Well, why did they wait till the last 2 days of a 3-month period to try to serve this? And then call and say, will you accept service? And if the answer is no, or if there is no answer, you haven't complied. The law on this is, it's going back to the Pickholtz decision in the Second Circuit and the whole string of Second Circuit decisions and district court decisions. And they're all in our brief. It's very clear that if you are going to use email service in federal court, you need written consent of the person being served. So, all right. Thank you.
Until that red light is on, you can keep talking.
Oh, okay.
Okay?
Well, I did have another point.
You don't have to. If you're good, if you're done, you're done. That's fine too. I thank you for your argument. And we've reached the red light now, so you see?
Thank you.
Counsel, you have 2 minutes on rebuttal.
Thank you very much, Your Honor. Very briefly, counsel is correct. It's a long opinion. It's also, on this point, obviously wrong, because
the weight of the evidence, isn't it the weight of the evidence that the arbitrators were looking at, and would that be a basis to vacate?
I think, given the factual finding that the arbitrators made, the court has no choice but to vacate, given that there is a factual finding, 2 of them, in fact, that we gave up something in exchange for the overrides. So it is, to your question, Your Honor, the unusual circumstance where the facts, as found by the arbitrator, are irreconcilable with the legal conclusion that they reached. You can't say, we gave up money and we suffered a detriment, and oh, by the way, there's no consideration. On the override versus voluntary compensation point,
I'm still not, the arbitrators below relied heavily on the fact that there was a filing saying there was no consideration.
Agreed.
And your argument was basically they misunderstood the form. It's basically what you argued. And so if this court doesn't accept that they misunderstood the form, right, you lose. And even if they did misunderstand the form, under the law that dictates Article 78 and arbitration agreements, you still can't prevail here.
respectfully, Your Honor, there are a lot of cases from this court, like Lerner and Fiorillia, where the court has stepped in and found manifest disregard when it is very clear that the arbitrators simply refused to follow the law. There is a factual finding in the award that says we gave something up. The comment on the form, it says we didn't pay any consideration. It was clear to everyone, including the participants, record at 269, who signed contracts about this, that what they were getting was a prospective reduction in fees.
All right.
On the service issue, briefly, there are plenty of federal court authorities that disagree with the federal court.
We're not going to go through that again, because on that, sir, the law is against you.
Thank you, Your Honor. Appreciate it.
Okay. Walcot versus Wheels.
And now for some much lighter fare.
Thank you.
We waited, we cleared the room.
We've been waiting for you.
Good old motor vehicle accident, right?
Yes, I just was going to say, my name is Evie Kazansky. I represent the defendants in this action. This is a classic scenario of a one-on-one motor vehicle accident. In this case, I'm actually not trying to defend the summary judgment. I'm trying to say that the judge actually was wrong. The plaintiff moved for partial summary judgment on a violation of 1128A, which is improperly changing lanes, and then also moved for dismissal of our affirmative defense of culpable conduct. In this action, I think you have two different versions of what happened here. This is not a straight-on motor vehicle. We have a scooter. The accident occurs on West 135th Street. Everybody agrees that there is a bus to the very, very far right. In the beginning of the situation, the plaintiff is behind the bus. Our car is further up on the bus. The plaintiff says the red herring of the situation is he says he always was in his lane. Our the client, the driver, basically says that as he's waiting to get in front of the bus, the scooter comes in between them. With respect to his summary judgments,
Did anybody testify that the scooter was in the driver's lane? The car's
no,
driver's lane?
no. So the argument is, from our perspective, is that even though he's saying he's in the right lane, it's actually, when you read the defendant's version, the scooter, not a car, a scooter came in between the bus and his vehicle. So he's slightly angled. So if the scooter's coming in between a bus and trying to squeeze in,
Does that mean that the scooter wasn't still in the right lane?
no, the argument is that the scooter is,
In between the lanes?
yes, in a certain sense. The bus, you have a bus.
How does see, part of the problem is he fills out an MV 104 and says the bus was stationary. As I passed the bus and I was changing lanes, the person in the scooter tried passing me. And then later he says he didn't see the scooter. So you can't have it both ways. You can't say, I didn't see the scooter, and then say, oh, that scooter was trying to go around the bus.
Well, in a certain sense, you can, because the bus
No, you
is to
can't.
the bus is to the left, and
He can speculate that that's what may have happened, but he can't say that's what happened because he doesn't see the moped driver according to his own testimony.
the plaintiff never actually says that the bus moved ahead and that he's staying in his lane. The point is, as the defendant make in opposition, we raised an issue of fact as to where the scooter was, when the scooter was, and the points of contact are to our right side and the scooter head on, which a reasonable jury could find that the scooter was trying to squeeze through the bus and trying to move up the lane to get ahead of us. That's all we had to do in terms of trying to raise an issue.
Is create a potential situation without any witness. Because you are putting forth a theory that's not backed up by anyone's testimony.
It's backed up by the driver's testimony that he's slightly angled waiting for the bus to go. The bus hadn't moved completely forward yet, and that he saw the scooter as he's trying to go.
And he was slightly angled. He was slightly angled.
He was waiting to turn
into the bus's lane.
It's like a bus lane, a driving lane, and then another driving lane. It's 135th Street. They're going towards the east side. So the bus they both agree the bus is there when they both turn on to 135th. So my guy's in the total left lane, not in the bus lane, and the bus is coming into the right lane, and then my driver is trying to go in front because further up on West 135th Street, it becomes one lane only, and then it's a left turning lane. So in opposition, his argument is that a reasonable jury could believe that the scooter, who already testified he was behind the bus when he turned onto 135th, and my car is forward ahead. When he's coming up 135th, he's trying to squeeze between the bus and the vehicle, and the points of contact are my right side to the scooter
Where
front.
was the driver's right side, though?
The driver's is to the left. The driver's right side is, I don't think he's in the right lane at all. He's angling with his blinker on, trying to go into the further right lane.
So, I mean, that contradicts even what he says, right? Because if what you just said is true, then the moped driver came into the left lane, but that's not what anyone is saying, right? Even your driver says that he was angled, and my question to you is that he's angled towards the right lane.
So that actually answers your question. If he's slightly angled to the right lane and ready to start moving into the right lane ahead of the bus, then the scooter had to have been behind the bus and squeezed between the two. And at the very least, that raises an issue.
Wouldn't that be an unsafe lane change?
So,
under the VTL?
With respect to the situation, you can have a violation, but also have a culpable conduct of another vehicle. So you could, I guess, split the baby. We could have violated a possible unsafe lane change, but that doesn't necessarily then excuse the scooter for trying to possibly squeeze through and try to beat both the bus.
My trouble with this is you described this, and I'm very familiar with 135th Street, right? So yes, there are 2 lanes of traffic and a bus lane. So there's 3 lanes.
Right.
And you said your client makes a turn into the left lane, and the bus is in the bus lane, which leaves the right lane completely open.
No, my vehicle, if you
I'm following what you said.
I understand that, but the testimony, I could be reading the testimony tomorrow. My person's on 135th in the left lane, correct. The bus, when he gets onto 135th, is in the bus area because that's right near the corner of Lenox.
Right.
Okay, so he's already there. The scooter comes after both of them. So
at this point, the right lane is clear?
Right. Look, if the bus is in the bus lane.
I understand what you're saying, but
bus lane is like a parking lane.
The bus wasn't
it's not
stopped
the right lane.
At the time, the bus was starting to move into the bus drive, not from the bus stop. The bus was ahead of the bus stop at the time of the contact.
All right.
Indicating that it's possible the scooter
You'll have
squeeze
time on
through.
rebuttal, and we could muddle through this muddy area a little more. Okay, go ahead. You got 3 minutes.
Good afternoon, Your Honors. Oliver Tobias for the plaintiff respondent. May it please the court. I think that this is becoming more complicated than it needs to be. So the defendant's appeal really seems to be based on 2 main arguments. One is that just the general idea that there's a discrepancy between the parties' accounts of the accident somehow should result in the preclusion of summary judgment. We already know that's not true. You have to look at...
Well, that usually is the case. When one side says one thing, one side says another, that's a quintessential issue of fact.
I don't disagree, but it has to be a material difference. So really, it's under either version, if you've got one version where the defendant is entitled to a finding precluding summary judgment and the plaintiff isn't under the other version, okay, I get it. But in this case, under either version, the plaintiff is entitled to summary judgment, and that's why I think, Judge Klein's got it right in the first place. So ultimately, what we've got here is, I agree with my adversary that there are...
So let me interrupt you for a moment. And playing devil's advocate. If your adversary is correct that your client was trying to squeeze past the bus as it was coming back into the right-hand lane, right? And perhaps the bus was cutting the moped off. I'll give him the benefit of the doubt, right? But he may have done so as the defendant's car was trying to get into the right-hand lane. Why is that not an issue of fact?
Because that's assuming a lot that's not in the record. So the reality is, and I believe this was pointed out, the defendant clearly testified that he never saw the plaintiff before the impact occurs in the first place. The testimony, to the extent that the parties agree on it, and I'm just going to go with the defendant's version because obviously they're entitled to every reasonable inference. So crediting the defendant's version of the accident, the bus is sticking out a little bit from the bus lane or the parking lane into the right moving lane. The defendant is in the left lane and he's proceeding straight. The defendant unequivocally testifies that by the time he starts to merge into the right of the 2 moving lanes, he has already passed the front of the bus and the bus pole. So that means that if he's past the bus as he starts merging, and the plaintiff is immediately to his right, established in the right lane, then the plaintiff has also already cleared the front of the bus. So if they are traveling essentially parallel to each other, and both of them have cleared the bus, and it's also undisputed that the plaintiff is in the right lane, right? There's no non-speculative testimony or any testimony, frankly, about the fact that the plaintiff somehow entered the left lane. There's none of that. So if the plaintiff is in the right lane and he's past the bus, and the defendant then starts to merge over, that is nothing other than an unsafe lane change. And I'll wrap this up, but to speculate, and I believe, respectfully, the defendant is asking this court to speculate about the fact that if the plaintiff is already past the bus, there's no evidence to the contrary, in fact, the evidence is that he did pass the bus, then all he's doing is driving straight in his lane when the defendant merges into him.
Thank you. You have 1 minute.
I'm going to direct the court to the record starting at 108 and then going to 265. Basically, the plaintiff himself is saying that the bus was in front of him. The bus was about 30 feet in front of him at the time. The bus was pulling out of the bus stop. He came to a stop behind the bus so the bus could go in front of him, which would make the bus in the right driving lane next to my vehicle. He was still in the right lane. The bus was to his right. The bus was moving from right to left. He stayed in the right lane waiting for the bus to merge out. He stayed in the right lane for 10 to 20 seconds, and then the bus began to move, and so did he, as my car was in the left lane, indicating that a jury reasonably could infer that he tried to squeeze between the two. That's all that's needed. I don't need to prove what was done and not done, and even if you want to suggest a violation, the same as in labor law and things of that nature, I could still get the benefit of culpable conduct.
Thank you.
I don't mean to rush the court. I just want the court to be advised that they are actually picking a jury today.
Oh, okay. Jury today. All right.
Thank you.
Thank you. All right. All right. Last but not least, Thread Council versus State of New York.
Good afternoon, Your Honor. Mark Whitford from Barclay Damon. I'm joined here today by Sarah Rathke. She's a member of the state of Ohio. Her Pro Hoc Vice application has been granted, and so with the court's permission, I would ask her to join for the plaintiff's argument today.
And welcome to you, to our fair city.
Thank you, Your Honor. Everybody here speaks very quickly.
That's a good insight for how we deal with things in New York.
The issue before us today is whether suppliers interfacing with the state, particularly during COVID times, are entitled to rely on plain contractual language directing the way in which a state must act if it wishes to reject products. The language in question is two sentences that states, within 14 days after receiving a shipment of the products, the buyer may inspect and check the quantity, appearance, and quality and attached documents and all other aspects of the products, including without limitation regarding quality issues and conformance to the product standards and specifications and this contract. In other words, this is very plain language dictating what the state must do if it wishes to reject product. As the trial court held in its 2022 order, it doesn't mean that the state is obliged to inspect anything, but if the state wishes to reject product or feels justified in rejecting product, this is the procedure that it has to follow.
Now, before we get there,
Okay.
the relevant contracts under Section 4 with the heading Inspection, Acceptance, and Rejection says, prior to each shipment of a product, the seller shall make a precise and comprehensive inspection of the goods included in such shipment as regards their quality, specifications, performance, and quantity, and certify to the buyer in writing that the goods are in strict compliance with the product standards and specifications and this contract. So my question is that a condition precedent to any duties of the state,
It's
the
not a-
buyer?
It's not a condition precedent.
Why not?
Because it doesn't use specific condition precedent language. Also, it wasn't
It
an
says you
issue-
must certify to the buyer in writing that the goods are in strict compliance. It says before, you must make a precise and comprehensive inspection of the goods. So I agree with you. You started by saying that your client and people situated like them should be able to rely on the contracts and the precise and clear, unambiguous language of the contract. And it seems to me that Section 4, that sentence I just read to you, is pretty clear and unequivocal that the buyer has a duty first before the seller has a duty in this contract. Why am I wrong about that?
First of all, I would say that the contract and the language that you've quoted provides duties to the seller and it provides duties to the buyer. That contract language doesn't limit the state's rights and responsibilities by virtue of the language that you cited. Now, as it happens—
Does it mean anything? So it's clear on this record that the lion's share of these surgical gowns that were being sent to New York State during the worst pandemic crisis that our country and our world has seen in over 100 years. And the state was painfully specific about the requirements and the kind of gowns that had to be produced because they needed to keep people safe. We were losing people by the thousands then, right?
That's right.
And so it seems to me like we're putting the cart before the horse when we start talking about, well, what did the state do to reject or inspect, when it seems to me the first thing that has to be established on this record is that your people inspected all of the gowns it sent and that they certified that they were in compliance with the contract language. And why should I even go beyond that until that is established in this record?
Because that issue was not raised or argued in the court below. Failure to inspect and failure to certify inspection was not an issue that the state raised in the summary judgment proceedings. So because of that, the record is incomplete as to the facts underlying what laws of motion did. For that reason, the trial court noted, but simply in a footnote, that there's no evidence on this record that laws of motion did or did not inspect and certify. That's true, but that was not an issue placed before—
Well, we know that's true because 95% of these gowns are not in compliance. I mean, the state of New York spends a fortune to safeguard its citizens with equipment that we need during a life and death pandemic in this state. And we contract with a company who says, don't worry, we're going to give you what you need at the specifications you require, and then we get garbage. We can't even use that for art projects.
Your Honor, my response to that is significant nuance. The language that you quote sets forth a duty by a supplier. That was not invoked or described as a reason for—
But it's the plain language of the contract, and I, as the court, I should ignore that plain language in the contract?
You should not ignore any plain language in the contract, but
Okay, so
equally—
why shouldn't I send this back? Because I don't see how this contract was evaluated without looking at that. I don't understand.
So I would say that it wasn't briefed or raised by the state contemporaneously in the rejection letter as a reason for the breach. It wasn't briefed in the court below, so the record is—
Wait. They were saying that the gowns were not in compliance, that the elastic at the sleeves was bad, that the fabric did not hold up to the specifications, didn't keep the fluids out, et cetera, et cetera. I don't know all the technical verbiage, but you know what I mean.
Yes, and that language in Section 4 is very clear about what the state has to raise in order to reject products. And it says anything relating to the contract, including this, what would in theory be a very extremely discoverable defect, in that if certifications weren't made, that would be immediately discoverable by the state. Wasn't raised by the state as a basis for rejecting the goods, wasn't briefed in the court below, and so now to raise it as an argument in which we have an incomplete record where everybody had a chance to raise whatever issues they want, and that is the manner, that is the nature of how litigation proceeds.
Right.
We can't send things back to raise arguments that parties didn't raise before. If we did that, we would never leave this room.
And you'd be back again and again, I agree.
While I enjoy it here. But also what I want to say is that the state was very clear that it was willing to deal with novice suppliers. In other words, this was a horrible pandemic, and because of that, the state specifically solicited offers and help from people it knew had never done this before, and Laws of Motion disclosed that it had never done this before. For that reason, that 14-day provision is very conducive to a process that protects the interests of both sides. In other words, if I, the supplier, am doing something wrong, I will learn of this before I am 2.4 million gowns in with $10 million in damages, and I'm a small business, and I've never done this before, and I've disclosed that. This contract is set up well to respect everybody's rights.
The state paid for this, one of the orders 50% up front.
That's right.
The other order 75% up front.
That's right, and the record is clear that Laws of Motion did this as a patriotic response to the COVID pandemic. In other words, it knew it was
I'm
doing
sorry,
it did it at a loss.
I feel, what other losses did the state endure? Because we have no idea where these gowns ended up and whether anyone got infected because of these defective, inferior gowns. We paid for, right, at least a good 60% of the entire total and got less than 10% of usable gowns. I think the state got hit harder than everybody here.
The state could have forestalled its damages by doing what it said it would do in the contract. and
Likewise, your
examining-
client, had they inspected the gowns, because not one of those gowns should have left the shop.
We know that based on 17 gowns only in a population of 2.4
Well, I'm
million.
sure those gowns are somewhere, right? Because no one can use them.
And
so they can be tested. And we can see perhaps at a time of trial, exactly how bad and how poorly these gowns were made.
And for that reason, Laws of Motion repeatedly asked for the gowns back, but the state said no.
Okay, thank you. You'll have more time on rebuttal. Now, why would the argument that I questioned your adversary about not have been raised?
I respectfully disagree with my adversary. It was raised. It was raised at page 2062 of the record. That's prior to litigation. It wasn't in the rejection letter. It was in correspondence after that, but it was
The
raised.
summary judgment motion?
It was raised in the summary judgment motion. We didn't cite the condition preceding section, but we did argue on the facts. Look, you didn't inspect the gowns, and the Court of Claims specifically found and correctly found that they didn't inspect the gowns. We raised it at the pleading stage as well, Your Honor,
So that's a nice factual finding, but unless you connect that factual finding to a theory that the judge can do something about,
Well, our argument on...
it's not up to the judge. I mean, I'm doing it, but the judge doesn't have the obligation, nor should they, make arguments for you.
No, Your Honor, but this court can resolve questions of law on appeal for the first time, even if raised for the first time. And respectfully, although we didn't cite the condition precedent language in the contract, we did say that the reason that we're not obligated to pay, or one of the reasons we're not obligated to pay, is, look, they breached their obligation to conduct these inspections prior to shipping the gowns to the state. That's unequivocally clear from the record, and once you have that fact, the legal conclusion follows directly. The Section 11 of the contract, which my friend did not refer to, says...
Well, let's go to the obligations that the state had, because after all, these typical contracts would use language of reasonable inspection, and you guys put in 14 days and put yourself on a clock and then didn't follow it.
We put ourselves on a 14-day clock to conduct the inspections.
And you didn't follow it.
They were not mandatory, Your Honor. We had a right to inspect within a reasonable period, ordinarily under the UCC, you're right, reasonable period. We replaced that reasonable...
Not when you have 14, you put 14 days.
You're right,
so now you're stuck with that.
We had a 14-day period in which to inspect the gowns. After the 14-day period, we still have a reasonable period in which to reject.
And how much time is that?
It's a reasonable period in the...
How much time is that?
Depends on the circumstances of the case. We did it...
And in this case, what was reasonable about waiting 58 days after you knew that the gowns had no markings on them? Already, the DOH had told you that the elasticity of the sleeves was questionable, the fabric was questionable, etc. And still it took you guys a long time to send samples for testing.
Well, Your Honor, respectfully, by that time, we'd already given notice that the gowns were defective. We'd already made that determination.
Can I ask a question? You said that after the 14 days, which, you know, you put in this contract because special for the COVID situation, where does it say that you then had a reasonable time after that, after the 14 days?
Oh, Your Honor, that's the default provision of the UCC, which is not replaced by anything in the contract. The contract says 14 days to inspect. The UCC says at section...
So you get to have both? You get to put a specific time period in the contract and have the benefit of what basically is the common law of the UCC? Really?
Yes.
No. No, that is not how this works. We don't say, oh, the contract says this, but you know, typically if we don't write it in, this is what we would do, so we should follow that.
Well,
Counsel.
Your Honor, Your Honor...
This is some of the sloppiest work I have seen. From beginning to end. And look, I understand we were in a terrible situation. But as stewards of the state's money, we expect more.
I understand, Your Honor, and the contract could have been more clearly drafted.
And followed up. So it's a bad contract writing, and then you don't even follow your own contract language.
Respectfully, Your Honor, I think that we did. We had a 14-day period in which we had a
You're
right...
going to make the argument again that you get to get the benefit of both? That you contract for one, but you get the benefit of the other?
I want to say not just a reasonable period to reject the gowns, but even if we failed to reject the gowns, I accept, just for purposes of argument, we didn't reject the gowns on time. Okay, that puts us in a position where the only consequence of that is that we accept the gowns. Under the UCC, that's what happens when you don't reject. Right? Once you accept the gowns, you then have a period of time in which you can revoke your acceptance. And even if you have accepted the gowns, the product of any kind, you can then assert a claim for breach of warranty provided that you give notice within a reasonable time.
But did you assert that claim here?
I'm sorry?
Did you assert a breach of warranty or a breach of whatever? Did you assert those claims?
We are asserting that we are not obligated to pay for the gowns because they were defective, not just because of we rejected some of them on time. We also revoked the acceptance. We also have a claim for breach of warranty that can be used to reduce, or in this case, extinguish the purchase price and leave us not owing any money. So yes, we have asserted that. We asserted that we don't.
Can I just, because I forgot now, looking at all these papers, how much did the state pay to Thread Council? Because you paid 50% on one order and 75% on another order?
That's right. My recollection is about 15 and a half in total that we have paid.
And about 10 million that is being sued for now?
Yes, ma'am. About 10 and a half is outstanding. We asserted, I want to get into why we did assert this reasonably in a reasonable time period. I want to remind the court that when we got to the point at which we learned that there were problems with the gowns, that was in late May. Prior to that, when we did an inspection of the Montgomery facility, we determined for the first time that there were problems with some of the gowns. That triggered a broader inspection. Prior to that time, we had every reason to believe that the gowns were compliant. Laws of Motion had represented in the contracts and the negotiations that they would meet the level 3 standards. They had said in the negotiations, we have found testing facilities that will comply with the FDA requirements. They had, as you observed earlier, they had promised us that they would do not just we had the may option to conduct inspections after delivery. They had a shall requirement to conduct the inspections. We had every right to rely on their promise to conduct those inspections prior to shipment. In addition to that, prior to placing the second order, we couldn't conduct an inspection at that time because the inspectors were quarantined with COVID. So we asked Laws of Motion CEO, Ms. Beege, are these gowns compliant with the contracts? And she said, and this is at 2077 of the record, Laws of Motion had conducted the exact tests required by the FDA to ensure independent compliance of materials. That was false, straightforwardly false. They had no capacity to do the testing. We were nevertheless entitled to rely on her representation to the state in deciding, look, we don't need to do these tests ourselves. We don't need to do this inspection ourselves. They've already done it. We don't have to do this now. We then did, a couple of weeks later, we did an initial visual inspection. The defects at that time on the gowns that we looked at weren't obvious. So it wasn't clear at the time that these were problematic. And so again, we didn't have a reason to look at the gowns immediately. We happened to look at them in late May in part of a, if I may finish my, we happened to look at them in late May and see, look, oh, there are problems with these gowns that we have discovered now in Montgomery. That triggered a broader inspection. At that time, we looked at all the 47 shipments that were delivered to 4 different state facilities. We found 16 or 17 different styles of gowns. It took time for the state then to determine, oh, these are all problematic. These are all defective. Within 2 weeks of that, we had nevertheless determined these are problematic. We sent the letter on June 12th. That was within a reasonable period in the circumstances, and a jury could not find to the contrary on this record. They could not find the state acted unreasonably here, and for that reason, it should be resolved as a matter of law in our favor. Thank you.
Thank you.
I'd like to talk a little bit about the fact that under the contract, it is not Laws of Motion's sole responsibility to protect the people of New York from, in a circumstance like this. The contract is set up to provide obligations on both sides. As to the point that the first inspection couldn't go forward, the inspector testified that it couldn't go forward when it was scheduled because they were put on COVID lockdown. That was released later that day. So tell me why the state doesn't get down there when it just happens to be conducting other inspections until more than a month later, May 29. By this point, the vast majority of gowns have already been supplied. And then tell me why it takes so long for the state, after this is raised in a facility that had stopped being delivered 2 weeks ago, why it takes so long to send gowns to actually be tested. Now, contemporaneously, when the state was conducting its visual inspections, its inspection forms for the Guilderland warehouse, which is the only one that was still at issue following the trial court's ruling, the quality of material is rated by the inspectors as good and okay in 2 out of the 4 forms that it submits. The other 2 forms just indicate that it is white opaque material in one instance and thin yellow material in another. For that reason, the state's June 12, 2020 rejection letter is ambiguous. It's coy. It states, and this is record 276 to 277, it states many of the gowns don't satisfy the level 3 requirement, and many don't meet 2 other requirements that the court held don't apply to these gowns and the state has not contested. Also, I will note that letter doesn't say anything about inspections. Last thing I would say is, of the Guilderland gowns, which are the ones that we've argued about the most, those came in 16 shipments. The state inspected only 6 gowns and never indicated whether those came from different shipments, which shipments, or the manner in which they were analyzed, other than a 10-minute visual inspection. In other words, the state cannot show that it inspected any shipment of gowns within the contractual period, and no reason at all why it couldn't have sent those gowns for testing sooner. Hellman testified, we only started talking about sending gowns for testing in July, a month later. Thank you.
Thank you. You have 1 minute, because you both appealed.
Thank you, Your Honor. She asked
Yeah, 2
for,
minutes.
she asked that I tell you why we didn't expect the gowns before May 29th, and I think I just went on quite a long explanation of why. We weren't required to test them at any time, and we chose not to test them because they told us repeatedly, over and over and over again, that these gowns were compliant, and not only that, that we had tested them.
Well, I mean, yeah, when you have lawsuits, I mean, you don't necessarily, you just necessarily believe that they said, oh, we tested. It's like, okay, great. I mean, you have a contract, you have multi-million dollars worth of gowns. I mean, isn't that sort of not really fulfilling your responsibility when it does say you could test the gowns? I mean, just to rely on the fact that they're okay?
Again, I go back to,
Your Honor, just,
my goodness, we're talking about people's lives. We're talking about the lives, not just of the patients, but of the doctors and nurses who have to wear these gowns thinking they're safe. And I get it, again, we were here, so we know what was going on in this city, okay? And I can certainly understand why, under the circumstances, when we were trying to figure out, you know, where do we put the bodies, because the morgue can't hold anymore, okay? That we don't have enough inspectors to go and look at pieces of fabric, that makes sense to me.
and I think that's exactly.
But, this lackadaisical, oh, we're gonna rely on you, a manufacturer who's never done this before, and you don't check not once whether these gowns are done properly? Shame.
Well, Your Honor, to be clear, we.
Shame. I'm done.
As excited about anything as she got about it.